My name is Joseph McDaniel, and I'm an Arizona bankruptcy attorney. And since 2005, I also get to tell people that I'm a debt relief agency and that I help people and businesses file bankruptcy. Today's bankruptcy question is, what do I say to collection agencies if I'm going to be filing a Chapter 7 bankruptcy in Arizona? Well, you can start with the truth. If you're not as young as you used to be, that also means you don't need to tie up any excess brain cells on a cover story. Here's the deal. Collection agencies are going out of business because if you have to decide between paying your mortgage or your unsecured credit card type debts, who are you going to pay? So collection agencies are much more likely to be aggressive these days than previously. But they also don't want to waste their time. In general, it's pretty simple. You tell them you've talked to a bankruptcy lawyer and that you're going to be filing a Chapter 7 or a Chapter 13 as the case may be. They'll tell you that they'll keep calling you until you can, quote, confirm representation. That is, give them a lawyer name and a phone number who will agree and tell the collection agency that the lawyer has been retained. Some collection agencies, but not most, will lie to a debtor. They'll threaten all sorts of things they can't do or won't do in order to coerce a payment out of the debtor. One thing to avoid like the plague is sending a series of post-dated checks over to the collection agency. The collector generally says that unless you send in 5 post-dated checks immediately, you'll be sued immediately, and that the checks will be held until the date written on those checks. Both of those are normally lies. That is, a collector almost never has the ability to cause a lawsuit to be filed against a debtor or to prevent such a lawsuit. The collector is working generally on an hourly basis, and they're just grinding through the day. But the multiple post-dated checks, if you send them in, tend to get deposited on the same day. And then the collection agency uses the threat of prosecution on a bad check charge to coerce payment out of you. That's bad stuff. If you know that you're going to be filing a bankruptcy, just tell the collector that you're going to be filing as soon as you get enough money to pay your lawyer. But invite the collector to call back frequently to check on the status because you don't want to forget to file that bankruptcy. And don't try to use bankruptcy as a threat because that won't work. The collector will receive the information about bankruptcy as a relief because after he confirms representation, he no longer has to keep calling you and failing to collect, which earns him bad marks from his boss. Bear in mind that you may eventually be sued by some unsecured creditor, but that generally takes some time. And if you file an answer instead of letting the matter go by default, it will generally take a couple or 3 months until a judgment is taken against you, which is a bad idea, by the way. That generally gives you plenty of time to get precise bankruptcy schedules ready to file. After you file your bankruptcy, creditors who are listed on the master mailing matrix stop calling because they're required to by law, and besides, it's not their first rodeo. Thank you very much.